Thank you. So now we leave the floor to Ulf and Matthias, or is Ulf to start? Yeah, okay.
I'm the president of Copy Swede, and
Yeah.
one could wonder, why is a lawyer a president of a collecting society? That's a little bit the history of one Nordic way. I'd like to say, I don't have a PowerPoint that will my colleague have explain the technology, but I want to talk about how we came to where we are today. And for us, it's union work from the beginning, because even the directors were considered employees in our labor legislation. And our organization, the union that owns our copyright administration, started their work 1895. Of course, the technology wasn't very far in those days, but we were able to organize very high organized, about 100% of all the actors, because in those days it was the actors, only them in the organization. So, and this is a tradition in Sweden, that the organization is very high. The Swedes love to be in cooperation. So, and this tradition is still very strong. So, the first time we had to discuss copyright was in the 60s, and in those days we had a copyright law, but actors didn't have full rights, and not directors either. But we went out in big strikes, I would say, against the public service, the radio in those days. I think it was 8 weeks strike. So we got our first collective agreement that gave royalties and use fees for the radio. And then when we had those agreements, we could go on with the television, the public service, of course, in the beginning. And then in the 70s, we had our first fights with the producers, because it's always, if you have a collective agreement, it's always the employer that you have to have an agreement with. In those days, it was easier, because the public service were the producers and the distributors. So it was natural to give away, through collective agreements, all rights, if we were paid for all uses. So this has been the tradition, and a very solid tradition in Sweden and the Nordic countries. But we've had to have industrial conflicts to gain these rights. In 1995, when the Rental and Lending Directive came, the first directive, it was made possible to give performers full rights, and so the Swedish government did. So the performers and the authors had the same right system. But there was a presumption. There was a presumption for in the early legislation for authors. So when they gave the actors or the performers the full rights, they said, very Swedish thinking, if I have a beautiful car, instead of saying I want to have that car, they say you shouldn't have that car. So that everybody got the presumption, instead of taking it away like they did in Denmark, for instance. At the same time, this is a presumption if nothing else is written. And we have never tried the presumption in the courts. And I would say that it is not a presumption that forbids you to have equitable remuneration, but you cannot say, you can't oppose the use of your recording. But at that time, we had, when you became member, you could give a mandate to the union to negotiate rights, but at the same time, if the actor was pressed by a producer, so he left. He would take the rights with him. So we started, because of this presumption, we started TROM, as you know it, administration of rights owned by the union. So we made a big propaganda out to our members to say, when the presumption comes, it's better to transfer the rights to us instead. And this was very successful. And today I would say we have more members of TROM than members in the union, and that could be a problem in the future. But it's but then you have to get something back. I mean, if you can organize yourself like this, you have to get something back. In the beginning, we said maybe you'll get your fee to the union back. And that's always something. And during the years, these agreements have been more and more successful. And another thing that happened in the late 80s, the DVD came, the VHS. And then the first time, all right holders started to discuss with each other, how should we manage this right? In those days, it was a right that you usually transferred to the producer, but we came together and we knew that we were getting cable transmission rights too later on. So we started the umbrella organization CopySuite in the late 80s. And also we had all the right holders grouped in this organization that we own as a, what do you say, ideell eller ekonomisk förening. It's every part, Lars will tell you about it, but Teaterbundet, the union owns a share of this umbrella organization. And it's very important. It's the organization, not the individual. And that, I think, Lars will tell you, is maybe the unique thing we have in the Nordic countries, that we have the organizations that own the organization, like CopySuite. But if I get back to this contract that we have in the union or in TROM, is as long as there is a collective agreement, that the individual right holder can transfer the right to the producers if there is an agreement in the bottom, so he or she will get paid by all uses. And I would say in the late 90s and early 2000 was the golden age for us. The royalties really rose, and the new technology we could handle. But then more and more we could see that the producers, it wasn't the producers that made the money, it was often third parties like cable operators and other distributors. So the tradition of giving all rights to a producer, if we get paid by all users, we had to, and that was complicated, to retain rights that usually was given very generous to the producer. So we had to have a period of taking back rights or retaining new rights. And this was something that the producers were very skeptical to, because they were used to be the one that made the different businesses. But it worked. It worked for the cable retransmission. The private copy is not a problem, as you know, because it's not transferable in that way. But then we have the digital area. And we have another clause in our copyright legislation that you probably heard of. It's called extended collective licenses. And this is a kind of legislation that is built on the labor law, because why we could expand through the labor law was that if we have a union has an agreement, everyone in the working place is bound by the agreement. The employer has to use these rules even for non-members. So that's why the things work in the labor area. So this idea was transferred into the copyright solution that Lars will tell you a little bit about. So everything has gone, I would say, fine, but now things are happening in the digital age. Who's going to gain the money? Are there any money when the DVD falls and the video on demand comes? Who should we negotiate with? What tariff should we put? Are there any money in it? And I think everybody is thinking about this. Not only right holders, our producers are really desperate. Even the cable operators are getting desperate. How should we keep the rights, and how should we make money on the rights? But luckily we have this legislation in Sweden that we can have extended licensing on this area. I mean, if it's the producer that exploits the video on demand, of course the producer has to pay. So our big goal is to ask the producer to cooperate with us, because now we're standing not with our producers, we're standing with the big five in the world, and a single union can't do anything. We have to keep together, and that's why we feel that our umbrella organization, Copy Swede, could be the place where we can go on negotiating and perhaps try to see if we can get some money out of this new phenomena. So for me, it's the organization and the cooperation, because especially when you handle exclusive rights, and I know that many organizations in Europe feel that to handle exclusive rights is very complicated, because it's a fine right, but you can give it away for almost nothing if you don't have an equitable remuneration in the same right. So in the beginning, when this European idea of equitable remuneration came, we were very negative, because we thought that our producers would come and say, well, now you get a little dividend somewhere else. Well, we don't want to pay anything for this. But our actors, anyway, through the international organization we have, has said yes to looking into if this is a solution for the future. But I think it's a long way to come, and I know that in Europe, one is discussing other things. How should you negotiate collective agreements? What is that? Could that be something what could help? Because I know that in many countries, especially in the foreign Eastern countries, many of the right holders are not employees. So one would say, well, unions is nothing for us, and we can't work like that. But one could, in Sweden, there is a court case that I haven't read. It was very short, but it's a court case in Holland. I think it's opera singers or opera choir singers that the EU said that they probably could have collective agreements even if they were independent, self-employed. But to organize yourself, you have to have an organization, and I know that in many countries there are no unions of historical reasons, or very few members. But there are collecting societies in most countries, and maybe the collecting societies could, because if you don't have any rights, especially in the exclusive world, you have nothing to collect. So maybe one should discuss in these countries to have a part of a collecting society to try to get to negotiate primary contracts in some way, organized. And especially for directors, I mean, directors are not very many people. One could get in touch with them, one could try to regain power, and I know in Norway this has happened the last years, because one could say, well, it's too late. That we should have done 1895. But I say it's not too late, and especially if you can guard the rights, keep the rights in an organization, then you're strong, because if you have the rights, the distributors need those rights, and if they're already transferred, you could maybe become more powerful. So that's, I think, I hope that there could be a solution, and especially with the new situation in Europe, where countries are in crisis, maybe the idea of cooperation and association would come back, especially if you have valuable rights that somebody wants to grab. Thank you. Oh.
But I have a question.
Yeah.
Thank you. Can you just explain to us the difference between Tromb and CopySwede, why there are two organizations?
Yeah, that's because we took in the rights to safeguard them, and then we can use it in our collective agreements for primary, but when we have, the union has the rights, they give it, transfer it to CopySwede. So CopySwede as an organization, not as an individual. That's the big, we have the rights in our organization. We give the power of attorney to CopySwede to make these complicated, big negotiations that could be with Netflix, retransmission discussions, video on demand, and we're getting our first agreements on the catch-up, start over solutions. And we hope that we would be powerful enough to maybe make a negotiation with Netflix or Amazon, because you never know. Maybe no one is interested in Swedish or other Nordic European films, but they maybe will start to produce, and so we have to be optimistic.
Okay, good. Thank you. Thank you.
I'm from the small country, Czech Republic. So my question goes like, did you discuss the possibility of some level of negotiation on European Union with such giants as Amazon, etc.?
We haven't discussed that, and you have to understand that our background, when it comes from collective agreements, so for us, the agreements we make, the union or our TROM is the national repertoire. If you come to like the next step, like Lars will tell you about, that's cross-border. How do we handle things cross-border? And that's the question that the EU wants to have a solution for too, but we haven't come there yet.
Just want to know, is there anyone who is out of Trump? And if it is, how you manage, this kind of right that you are not holding?
Yeah, I can say that, as I told you, we're a union with most of the authors and performers except music. And for instance, the directors have been with us and left a couple of times, and we have a group that is not organized the same way as the actors. But because of all work starts in a primary contract, our agreements on the floor for a director is from the beginning as a laborer, but most directors have their own businesses. But we have a special clause in our agreements that say that the self-employed, they can't reduce the royalty because there's a lot of self-employed. So we get the full royalty for all, and we have the right to distribute it to these people. And We have the retained rights like cable, retransmission, and catch-up and things like that comes at the same time. So I would say that many directors that has nothing to do with the union has gained a lot of money on our work. So of course Håkan tries to make them come back, and maybe they've never been in because they've been working a little bit like small business people and they haven't thought of these things, but they get hundreds of thousands of money. So we should, and I think the Directors Guild, the Swedish, has gained in, and then you can be, many have a contract with us, but is not member of the union. So that's a possibility.
Hello, I'm Björn Alexander Brem. I'm the lawyer of the Norwegian Film Union. Ulf mentioned a little bit about Norway, and I've also been working a lot with trying to keep rights on the secondary level. Typically, we have big difficulties with the national retransmission rights, basically. So what we did, we and our members really wanted to assign exclusively all copyrights to the union. And then we gave back the right to negotiate on their own copyrights level, but we kept the rights on the secondary level, which means that due to competition rules, it should be okay. It's also important that your own member can take back specific fields of their own rights. It shouldn't be too difficult to get out. But of course, when you're first in and you get money, very few would like to get out, because it's almost impossible for one single copyright holder to keep rights. And the construction can often be that these rights are already sold before you start to negotiate. If you, for example, have an agreement between the distributor and the broadcaster 1 year ago, and they agree that the broadcaster will make sure that all rights are cleared. Then they will enter also before the copyright holder negotiates an agreement with the broadcaster, and then the broadcaster, the producer, and then the producer will come to your copyright holder and say that I already sold your rights, so take it or leave it. This is the problem that we had to turn around by saying that from a specific date they cannot pre-sell the copyright holder's rights, because the rights are now kept by the union, and we say no to that, to assign also third-party rights to get an equitable remuneration.
I was just wanted to add one thing that we feel, and especially when we see in Copy Swede that the producers are very vulnerable anyway in Sweden. We have one or two big producers, but most of them, they don't even think about rights. They have a good wage, a nice house, in a good environment, and a big car, and that's what they don't have anything else. They sell their rights to broadcasters and things. And now when everybody's losing money, we're trying through our Danish producers, because the Danes, as you know, are very good businessmen, and they keep together and have a discussion, shouldn't we do this together? So we have a little working group, and we're trying now to get together with the producers and say, what should we do in the future? Should we go on fighting each other down here, or should we decide how much is for the producer, how much is for the authors, and then we go up and take a discussion with the broadcasters and the other distributors. And I think this is the only future.
We have I believe it's not a specific situation in Slovenia, but the biggest producer, audiovisual producer, is national TV. And they're not the big budget producer, but for sure they're the biggest producer in the quantity of the produced audiovisual works. And the trouble with them is that they're used to acquiring all the rights, all the material rights from the authors. So actually, an author who would like to negotiate with them actually is left to just one decision, either to live or to retain the rights. So, because if she wants to retain just a part, not all, but just a part of the rights, he gets cancelled. And there are, of course, always a lot of other authors who are willing to transfer all the rights just in order to gain some money to be able to live on. So I'm sure that you encountered this situation in your country. How did you deal with this? And what would be your suggestion where to start and how to start with a negotiating process? Because our unions are not so strong in that field as yours. So where to start?
Yeah, I don't know the legislation in your countries if you have the right to be an employee or not, but probably you're not. So one has to organize oneself in some other way, and you have to do it in a way that it doesn't offend competition law. And I would say it wouldn't be if you do it in the right way. That you have to take a discussion. Of course, people have to live, but I go back to Norway. That Bjorn could speak to his members and enthusiast them to try to get progress. So if you, as always, if you can get the majority of your members to say, from this date, we won't work, well, we won't take work if we don't have these rights. And of course, if you only do that with 50% of the directors, then you're in a catastrophic situation. But if you can, by discussing, by using other examples, maybe you could understand that. And then the other thing is, if the EU would go on the line of an equitable remuneration, I mean, I understand that that would be a very good thing for you that has not the possibility to organize yourself in the way. But I wonder if maybe, of course, Norway has the same tradition to organize themselves as we have, but it wasn't very organized, and it was 2 directors groups. But when they saw that they could make an impact, they joined, I think it was 2 weeks. And if I understand, you had an organization, it was split in 2, but you didn't have very many primary rights. So you were a little bit in the same situation as many here, that you didn't have a strong collective agreement, but you started on the secondary money instead, and then you're going to try to get tariffs. But of course, there has to come in some money, because otherwise people give up. You have to, we started 95, and we said, or even earlier, that you could maybe get your member fee back anyway. And now, I mean, we distribute together with Copy Swede around, for our members, I would say 60, 70 million Swedish crowns on the Swedish repertoire. So they've gotten their fee back anyway.
But just to sum it up, I think you're correct, Ulf, when you said the first step is to have
Discussion.
Organization that you can organize the vast percentage of the market. We have now maybe 90% with the film directors also now back. And then the question is to how to get them to administer your rights and to ensure them that you're just doing...
That you're not a crook.
No, you're just ensuring something they can't do themselves, because it's impossible to stand alone on this. So, and it's impossible almost to explain also this retransmission rights, and it's really complex. So our experience is that when some key right holders are explained to, then some colleagues of them say that they signed, I want to sign too.
Yeah.
And then it starts.
One thing we've done is that when we get in the money, many politicians say, well, why should X, the famous actor or director, get the most? Because we make the share what kind of wages you have in that film. But at the same time we say, if we start manipulating and saying that everybody should have the same, they will leave. Then we'll be like the composers now. The big composers in Sweden are leaving, starting their own. Of course, music is another business, but so I think it's very good that you have the stars, but they feel that because then the other people want to join.
I have a question that relates to some of your presentation and also Špela's comments about the presumption of the assignment of the director's copyright. We don't have that in the UK, and it's very important that we don't have it. What we do have is a lot of occasions when producers don't actually issue any contract to the director. And that creates instability, obviously, and uncertainty. And we deal with a lot of cases at Directors UK when a director has been fired off a TV show or a film and they have no written contract. But because there's no presumption, that means we can argue to the production company, unless you issue a contract, you won't have an assignment of the director's copyright to enable you to exploit your work. So that draws them back into a contractual relationship with our director. And you know, you sometimes come across a producer who says, well, I don't need it, and you have to tell them what the law says. But we also threaten to go and tell the broadcaster that they are about to take delivery of a program that does not have all the clearances of rights included. So presumption of assignment for us is a very dangerous proposition and would stop us protecting directors' rights.
Nobody likes presumptions, but many governments have this in their legislation.
Well, thank you very much. It's very nice to be here, and I have been asked to talk a little bit about Copy Swede as an example of a collective management organization and the structures that could be a little bit special. My name is Lars Grönqvist, and I am the Chief Legal Officer at Copy Swede. Copy Swede is an umbrella organization established to coordinate negotiations and agreements in certain areas of copyright. We were established in 1982 to deal with the growing market of cable retransmission, primarily developed in the early 80s as a feature connected to the cross-border, the spillover of terrestrial broadcasts from the neighboring countries. This was not, however, our first collective agreements. We were actually making agreements on the publishing of DVD titles as the first agreements in the mid-80s, and was negotiating agreements on retransmission with the cable operators for quite a few years. The first agreement was made in 1989. But still, our main areas of operation, you can see, is the licensing of audiovisual works in certain areas of secondary use. And also, one other big area that we work in is the Swedish system establishing the compensation for private copying. And of course also the distribution to the right holders. Well, Copy Swede is a cooperative economic association, and our members are the organizations that represent authors and performers in Sweden. Together, those that you see on the slide, those organizations represent all necessary authors and performers in audiovisual works that participate in, for example, film and television broadcasts. And as Ulf already mentioned, one important thing with the kind of CMO structure that Copy Swede represent is that we do not have individual authors as members. but those 14 organizations. Well, but since one of our primary areas of business is to license rights in television broadcast for retransmission, unaltered and simultaneous retransmission of broadcasts. Those also includes rights belonging to the broadcasting companies, of course, and different kinds of producers. And since producers are not members in Copperswede, we do have cooperation agreements with both the broadcasting organizations through a cooperation organization that they have founded in Sweden, and also with the phonographic producers IFPI, through IFPI, IFPI and the film producers. And now this slide is intended to give you a view over how we as a collective management organization get the mandates that we can use to enter into agreements with the users. And it's, as you already heard Ulf explain, it starts with the authors and performers. And to add to the discussion on how this is made in the first step, I could say that it's based on as we have talked about for a while now, the keeping of rights in the first contract. And typically, this is made possible through the organization's standard agreements or collective labor agreements that simply had provisions to keep the rights. And then the authors and performers authorize their own organization to handle the copyright within the certain area of use. And through the power of attorneys and the membership agreements, and it can also be regulated in the organization's statutes. And then those organizations and guilds transfer those mandates to Copperswede through the membership agreements that they have with us. And as you remember, the 14 membership organizations, member organizations that we have, that Copperswede consists of, they are of different kinds. They are both CMOs themselves, they could be trade unions and professional guilds. But the system works in the same way for all these three categories of organizations. They have the rights which they transfer further to us. And then it's possible for Copperswede to make agreements, licensing agreements with the users. For example, a cable operator wishing to have the possibility to retransmit television channels. And those agreements are then based on the exclusive rights that has been transferred to us. They are based on the exclusive rights needed for the kind of use that's asked for and licensed in the agreement. And this is a kind of example of the main areas that we are licensing audiovisual works today. But still, the most important and biggest licensing agreements concerns simultaneous and unaltered retransmission of television broadcasts. We do license around 100 television channels, most it is Swedish and European public service television broadcast channels. And lately we also have added retransmission licensing, including IP technology and over-the-top retransmission. That is retransmission services over the internet. And we have also added some on-demand services recently, for example, start-over services and catch-up services mostly in direct connection to the retransmission. So the cable operator, for example, asks for the possibility the rights to be able to put up different kinds of start over and catch up services in connection with the retransmission. And of course TV everywhere functionality, which the possibility to see the television package outside the home, and that is made with licenses of the OTT or over-the-top retransmission. And just briefly, this licenses, most of the licensing area that Copy Swede works with also are covered by some kind of extended collective license regulation in the Swedish Copyright Act, and I have listed the most important ones. There are 6 provisions in the Swedish Copyright Act regarding extended collective licenses, and there's also a 7th one which is constructed like a general ECL provision. And I was not thinking of going into detail about how the ECL system is connected to this, but if you have any interest in that or questions, you are more than welcome to approach me. And now I also been asked to talk a bit about the Swedish system of compensation for private copying. And we do, as you probably know, also, like most European countries, have exception and limitation regarding the possibility of making copies for private use. And therefore, we do also have a system of fair compensation regulated in the Copyright Act. And it is done in the Articles 26 K, L, and M. And the levy system is based on, the Swedish levy system is based on a levy on products possible to put private copies on. It only covers sounds and moving images, not text or separate visual arts, other than when those are incorporated in an audiovisual work, of course. And there is an open definition in the law on what products that are covered. It is not pointed out in detail, or it's not decided by any authority or ministry. And the legal definition is constructed in a way that it is products especially suitable for private copying. It's more or less those words, but in Swedish. Especially suitable for private copying that are covered by the liability to pay. And it is like here, it is the importer or manufacturer that is liable to pay the levy upon the time of import. And there are also, as you can see to the right, there are some explicit exemptions to the system or the liability to pay in the law, and it is, for example, when products are to be sold to professional users and when products are intended to go on export. Well, since the liability to pay occurs on import, we have since 1999, when the law was into force, we have established a system through agreements with the importers to handle the exemptions in a more practical way. And that is that they pay the levy, they have to report, of course, what they bring into the country and their selling of the products, but they pay the levy first when they sell it to the distributor in Sweden that sells to private users, private persons. And in that way we can easily exclude export, and we can also have an easier way to exclude professional use. Now, another thing with the system in the Swedish Copyright Act is that the levy is stated in the law. And it's two different tariffs. It's one for analog products. As you know, they are declining. And another tariff for digital products. But it's also complemented with a special provision on the possibility for reduction under certain circumstances. And those certain circumstances are quite common. So it's not actually the levy in the law that it's the levy on the actual products. But this system with a fixed levy and the possibility for the importer to actually have the right to have it reduced leads to, in a way, a kind of negotiation situation, that we have negotiations with the industry on what tariff would be the right one. I will also have a few slides to show the tariffs, how they are, to what level they are, and this are, as you can see, for the old magnetic band cassette, C cassettes, they actually still exist. We do have quite substantial income from them. Well, it's relative, of course, it's not that substantial, but I think it amounts up to about 200,000 Swedish crowns per year. So it's not a lot of money, but still, we are surprised every year. And this is actually, for the analog tapes here, it is actually the levy set out, it's the amount set out in the law. So that's not reduced, and that's because also that the prerequisite for reduction are not that obvious on those products. As we saw previously, also during a couple of years, the CDR and recordable CD and DVD discs were very important. They stood for a quite significant part of the collection of private copying levies in Sweden up to about 2007, where they peaked, and then they have turned down. The levies, those levies are negotiated. They are not on the level that is stated in the law. And there are two main, you could say it's 2 or 3 main situations where the importer has the right to have the levy reduced. It's one is that was most important in the in 2005 and in those years. It was the risk of disturbance on the market. If the levy was so high that the black import or that the Swedish market for the products were too much disturbed, then the levy would be too high. So we did surveys together with the industry to monitor this, and this was of course also before the Opus judgment stating that the levy should be paid in the country where it's sold. So this was more of a problem when internet stores could sell without levies directly to Swedish customers. But another reason to have the levy reduced is what the storage, what the product is actually, the private copying itself. What is copied more or less on the product. That could also be if it's more other things than private copying, for example, or things that's not liable to be remunerated as private copying, then it could be a reason to negotiate the tariff downwards, and that's what's happened here. And Nowadays, this is perhaps our most important product group. It is the set-top boxes with an internal memory. And as you see, it's in practice, all set-top boxes sold in Sweden nowadays have a storage capacity over 320 gigabytes. So it's a fixed tariff on 320 Swedish crowns. Well, as we heard previously, the private copying has moved over the last years from those traditional and quite obvious products for private copying to products that is multifunctional, and it's used for other things than private copying, but also to a large extent used for private copying. And this means that we have tried to negotiate with the industry about the appropriate levels on levies, the appropriate tariffs on new products for quite a few years now, concerning computers and internal hard disk drives, and also loosely sold internal hard drives, external hard drives, tablets, and yeah, those kinds of products. And the industry was not that interested in negotiating the tariffs because they didn't share our view that those products was included by the system. But still, actually, regarding external hard drives, we have actually negotiated an agreement of those levels that you see here, those tariffs. 1 Swedish krona per gigabyte. It's 1/4 of what's stated in the law, and as kind of a roof on 80 Swedish kronor on this kind of equipment. I will get back to that, but this means that for 2013 we had a collection of private copying levies on 105 million Swedish crowns. It's a bit less than it were on the CD and DVD peak year 2007, but still it's actually increasing thanks to the new products that we have entered into the system. And the collection cost is very low, and I would say that, as my next slide will indicate, it's very much connected with legal proceedings that we have to issue. Because we do have some legal disputes regarding the new multifunctional products. We had in 2012 we had an arbitration with an alliance that called themselves UMA, which consisted of 21 biggest companies in Sweden importing external hard drives and USB memories. They were together representing about over 95% of the import to Sweden of those kinds of products. And we had a negotiation about the tariffs. They accepted that, but they then said that we do not agree that the legal definition, especially suitable for private copying, is applicable to those kinds of products, because perhaps they are suitable, but they are not especially suitable, they said. And they said, so we agreed on having this specific question, specific question tried by an arbitration, and the arbitration board was very, very competent, very unusually competent even, because it consisted of 3 active Supreme Court judges in Sweden. And their judgment was very good, because they said that these products are especially suitable for private copying. So we were very happy with that. So, but we have also 3 court cases right now. It's against Sony Mobile regarding a Walkman mobile. You know, this kind of music telephones no longer existing, but they were quite popular in 2009 and 2010, which this court case is about. Their import of those kind of phones those years. And it's all about the same. It's about the same, those 3 words, especially suitable for, and they don't agree. We have had one ruling in the district court to our favor when it comes to the Sony Mobile case. And we also have a court case against the biggest telecom operator in Sweden, Telia Sonera, which were exclusive importers of iPhones for a couple of years. They no longer are that, but they were. And therefore we have a court case against them regarding iPhones. I could say that the industry is paying levies for iPod Touch as an MP3 player, but they think that an iPhone is not especially suitable for private copying. But we had a judgment. We had also there. We had a judgment in the district court to our favor, and both those cases are being tried in this next court instance in spring this year. And we also have a court case against Samsung regarding computers and tablets, and it's the same question. They don't believe they are especially suitable for private copying. But at the same time, there are companies actually paying for those kinds of products, and there are some part of the industry not paying for them. And finally, this is a terrible slide, I know. It's probably completely impossible for you to see anything on it. I thought I would say a few words just briefly and just very briefly about the distribution of the remuneration in an umbrella collecting society, because since we do represent all right holders in a television broadcast in the retransmission of a broadcast, including the broadcasting company and the producers, we do have to split the remunerations in a few steps. And the first step is the split between the Copy Swede groups, the authors and the performers on one hand, and the broadcasting companies and the film producers, television producers on the third. And as you can see to the right, this split is fixed and has been so for many years. But it's negotiated. It's not demanded by the government or by the system itself. It's negotiated between the parties. That it is 35.5% to the authors and performers groups, and 35.5% to the broadcasters, and 29% to the producers. And then in the next step, where it's impossible to read almost anything, there is first a split between television channels, the channels that we have licensed. There is obviously the split is already done when it's a price per channel, and there's also an exchange. It's a split out to the left with our organizations that we have reciprocal agreements with, and also to secure that the money to the foreign organizations that we have agreements with, their parts. And we also receive money from the same organizations regarding most often Swedish programs in foreign channels in their countries. And then we do a split among the organizations because, as you know, we had organizations of different kinds as members. We have organizations that are CMOs themselves, and we have trade unions and organizations. Among some of them have their own distribution systems on the individual level, and some don't. And so first there's a split among different right holders groups. And when the group split is done, for example, the money for the composers are transferred to the composer organization for further distribution, and so on. Yes, and when it comes to the private copying levy, it's distributed in a similar way and impossible to see. I can say that we do have, those pictures are from our distribution booklet that we have on our website in English. It's a little bit like a transparency report. We publish all the figures and how they are distributed. The private copying levy is distributed in a little bit different way because it's supposed to be distributed with the actual copying taking place, taking into account. So we do surveys several times a year to know what people actually are copying, on what and what kind of content, if it's music or if it's films or television, and the source where it's copied from, and from those statistics we do a split. Thank you very much.
One quick question about the licensing areas that CopySuites cover. You mentioned catch-up TV and VOD. Does that include subscription VOD as well? In a way, not as a whole service. We do have an agreement that we license certain productions produced by the public service television company in Sweden, and this, yes, you can fill in, but yeah.
Just a microphone.
I can talk when you are, yeah. So it's limited today to the public service companies' own productions, where it's a chain of provisions in the primary agreements and the agreement with the public service television company that we are doing the licensing of the VOD, even the VOD subscription, but it's title by title, not as a whole service.
But this is our big challenge, and I'm happy to say that we have, I hope, the first writing in our collective agreements that we keep the rights for SVOD production. And that's the plan, that we should put this right in the CopySuite instead. So that's to try to put more and more primary rights into this organization.
Sorry, just I want to know, how is the reaction of I mean, let's say the public opinion about these levies? We in Italy, we had all the people, all the consumers against us. What about in Sweden?
We do have that as well, yeah. But we think that it's a quite small but loud group of consumers. That sounds a lot that are against the levies, yes. But still, we feel that the support is also quite strong. It's no opposition against the levies among the politicians, for example. They do handle any questions about the blank tape levy. They do most often answer that it's handled on the EU level, so they don't actually touch it.
Okay. Do we have a... Yeah.
Maurizio asked about the people. And you say that in Sweden the companies of supports, hard disk and digital supports. They don't agree to the definition of a specialist suitable for. In Italy, it happened something they were much more aggressive, the companies. Do you know what Apple and Samsung did? When our Minister of Culture updated the private copy from 0.95 cents to €4 for an iPhone of 64 gigabytes, do you know what they did? Usually, iPhone all over the world, they have a fixed price. They recharged the price of an iPhone of €4, saying because of private copy. And Samsung did the same. So can you imagine how impressive it could be to the consumers? Yeah. Do you think it's the same? There is an agreement between this company, this big OTT like Samsung and iPhone also in Sweden? Or because I think there must be a correspondence. If they don't agree, I mean, the question is, do you think that it's going to be an agreement of the companies to protest and to combat the principle of private copy? Thank you.
Well, I think it could be, but today those companies don't pay. So they don't, since they don't pay the levy, they don't add it on either. But I heard it as an argument. But the industry, as they come together, their position in Sweden today is they have chosen to say that of course the right holders should get a compensation. So that's the first thing that they say. But this is an old system that does not work because the compensation is taking out on the wrong products and products not actually used for private copying. So they are arguing that it should be a state-financed system.
Probably it's the time for all the organization in all the European Union to find a general agreement, because another example which is very strong is that in Germany an iPhone costs something like €70 less than in Italy, but they charge €36. We charge €4. So I think probably it's the time for all the collecting private copy and CMO in all the Europe to work 3, 4, 5 days, I think, and until we find a general agreement to face the OTT and to make a proposal to governments, the European and the local. Yeah. Thank you.
Dagmar?
In Austria, the levies are collected because the law is not sure yet whether after the cassette, the other medias also fall into private levy. So what the companies do, they collect it from the consumer, showing the consumer how much he has to pay. But since the law isn't clear yet, the authors don't get anything of it. So they just keep it on an account until, and this is going on since years, until it is clear, the law is clear, and then presumably we get some money. So they collect the money. The consumers are really hot at us, and we don't get the money. So that's another situation you might not want to have.
Thank you. I think we have to stop here and have a coffee break. So thank you very much, Lars.